Welcome to our Small Business Survival Series. This is Nancy Smith, Executive Director with the Shadow Country Chamber of Commerce. And joining me today is Melissa Olson, who is the shareholder in charge of human resources for Kerber Rose. So welcome, Melissa.
Hi, Nancy. Thank you for having me.
Certainly. Melissa's going to share with us today information about unemployment, about the emergency paid sick leave, and the emergency family medical leave. I hope I got all that right from an HR perspective. So she is the expert, and she's going to take it away.
Great. So we're actually going to be talking about two different pieces of legislation, but because they somewhat intertwine, we're putting these all in one presentation. Generally, if I'm getting questions from our clients, they entail a little bit of both. So the first thing we're going to talk about is the Families First Coronavirus Response Act, and that piece of legislation entails two major provisions. This was passed very quickly. I believe the actual legislation was only about 88 pages compared to the CARES Act, which I believe was over 880 something. So it was very, very short. Unfortunately, because it was put together so quickly, due to need, and it was a good thing that they did put it together very quickly. There were a lot of unanswered questions. The subsequent clarifications that came out of the Department of Labor were actually about twice as long as the actual bill itself. So we have the first piece of this legislation was the Emergency Paid Sick Leave Act, or as we call it, the EPSLA. The second was a significant expansion to FMLA. That doesn't look a lot like FMLA as most people know it. So we're going to talk a little bit about how this differs from traditional FMLA and how that interplays for those employers that are beholden to FMLA. We'll start with the Emergency Paid Sick Leave Act. What this law does is allow for 2 weeks or 80 hours of paid sick leave to employees of employers that have less than 500 employees. So, and there's various reasons that an employee can elect to take this sick leave. And there's two ways that it can be paid out. There are certain reasons that an employee can gain 100% of their pay. And there's certain reasons that it would only equal 2/3 of their pay. Now, any pay that is paid out by an employer under the EPSLA is 100% reimbursable on their payroll tax credits. So there is documentation that is required in order for the employer to obtain those tax credits. So we'll talk about that a little bit at the end of the section, because the same documentation is required for the EFMLEA. So the first reason is that an employee is subject to federal, state, or local quarantine or isolation order related to COVID-19. Most of our quarantine orders have not prevented anybody from actually going to work. Our streets aren't shut down, so it's pretty unusual that this is going to apply at this point. What we've seen most often is for reasons under number 2, where the employee's been advised by a healthcare provider to self-quarantine due to concerns related to COVID-19. So you might see that if a family member or somebody they've come in contact with has tested positive, they may be quarantined, just as a precaution. We're at a point now where testing is a little bit more available than it was a few weeks ago. But up until relatively soon, we'd see a lot of employees that just weren't getting tested, but were advised to self-quarantine. So under number 2, employees are eligible for 100% pay up to a maximum of $511 per day. Number 3 is that an employee is experiencing symptoms of COVID-19 and seeking a medical diagnosis. So this reason would occur if somebody's symptomatic, they haven't been advised yet by their physician to quarantine, but they are going to take the day off to try and get some medical advice. So under this situation, the employee would be eligible for up to 100% pay, and again, up to $511 per day. The reason number 4 is that the employee is caring for an individual subject to the quarantine or isolation order and has been advised by a healthcare provider to self-quarantine. So this might happen if you're taking care of a parent or a loved one that is subject to quarantine and they desperately need your assistance in monitoring this. Under this circumstance, the employee is eligible for 2/3 pay, but only up to $200 per day. So this does reduce a little bit. In subsequent clarifications that the Department of Labor has put out, they have stated that the individual the employee is caring for doesn't necessarily need to be an immediate family member. However, the employee will need to establish that they have a reasonable responsibility to provide care for this person. So the neighbor down the hall they've never met and don't have a relationship with wouldn't qualify. However, Uncle Jim that has no other relatives in the area, absolutely. It doesn't necessarily need to be an immediate family member, but there should be an established relationship. Number 5 certainly is also one that we've seen quite a bit with the closure of the schools. This was certainly one of the reasons why this legislation was rushed as it was. If you look at the dates, this came out very shortly after many of the schools throughout the nation have been closed. So the government wanted to make sure that there was some protections and wage replacement for those parents that could no longer work due to their need to provide care for their son or daughter. So number 5 is really, caring for the employee's son or daughter if this son or daughter's school or place of care has been closed, or if the child care provider is unavailable. Again, for this reason, they have clarified that the child care provider does not need to be a licensed provider. We've certainly seen a lot of situations where the grandparents were typically providing care, and due to a high-risk situation, it was decided they no longer should provide care for a young child. So that really can be interpreted a little bit more loosely than what we originally had thought. This is eligible for 2/3 pay up to $200 per day. And number 6 is easily the most ambiguous reason. This allows leave for an employee who's experiencing any substantially similar conditions specified by the Secretary of Health and Human Services in consultation with the Secretary of Treasury and the Secretary of Labor. So we're about a month out from when this legislation originally came out, and they have yet to clarify what those similar conditions are. But to provide an example, we had a client whose employee was diagnosed with pertussis, which is whooping cough. It is an illness that presents very similarly to COVID-19 with terrible coughing. It's also highly contagious. And under this guidance of number 6, I advise they allow that, along with documentation from the provider, for this employee to take off. The leave is capped at 80 hours for full-time, or the equivalent of 2 weeks for part-time. And there's all sorts of calculations available from the DOL on how to calculate that part-time. So the easiest way to remember how much you pay for what is, generally speaking, if the leave is taken for the care of oneself, it's going to be 100% wages. If the leave is taken for care of others, it's 2/3 wages. The only exception is the similar condition provision of number 6, that is also 2/3. So let's talk about the Emergency Family Expanded Leave Act. Again, this applies to employers with fewer than 500 employees. All full-time and part-time employed by the company for at least 30 days from the date requesting leave are eligible. This varies significantly from regular FMLA. Regular FMLA requires 1 year of service. this provides 12 weeks of FMLA protected leave for the following reason. And the only reason allowed for this expanded FMLA leave is to care for a child due to a school closure. So the provisions of the medical that we typically attribute to FMLA really doesn't apply for this expanded piece. This really is only to care for a child. They further clarified that it is only to care for the employee's son or daughter as well. So a grandparent who is typically taking care of their grandchild, unless of course they have guardianship, generally wouldn't qualify. So the first 2 weeks of this the first 2 weeks of this leave is unpaid for the specific reason that that really is going to be covered by the expanded paid sick leave. That makes sense. So generally, you're going to see the expanded paid sick leave go into place the first 2 weeks, and the next 10 weeks would be paid under the EFMLA. So the EFMLA is going to run concurrently with that paid sick leave for a total of 12 weeks. The employer may require that PTO run concurrently with the paid weeks of the expanded EFMLA. So if the employees want to take paid time off to get to 100% of their wages, they can do that. However, the employer can't require the employee to take that paid sick leave for those first 2 weeks. So an employee may elect to save their paid sick leave for another time in the future. So as we said, the first 2 weeks of the expanded FMLA are unpaid. The next 10 weeks are paid out at 2/3 wages. And again, the employer and employee may agree to top off that 2/3 to equal an amount of 100%. So those employees are made whole during this time. What has not occurred is that this does not provide an additional FMLA allowance to employees. So it's a total of 12 weeks total for the EFMLA and FMLA combined. So if you had an employee that had taken maternity leave or other FMLA provisions over the course of the last 12 months or whatever your established measurement period is, they would not get additional time. So if they took 5 weeks of regular FMLA, they would only have 7 weeks left of the expanded FMLA leave. The documentation has been clarified in subsequent guidance from the Department of Labor, and so this documentation needs to be kept on file for a period of 4 years from the date of the documentation or the date of the leave request. And the onus is on the employee to provide this documentation for their employer in order for this to be approved. However, the DOL has absolutely stated that employers should be very cautious about denying leave and allow for some time that employees can provide that documentation. So I would be cautious on denying leave because the documentation hasn't been put in place. The documentation needed, depending on the reason for the EPSLA, is a little bit different. But for the expanded FMLA, the employee will need to provide the name and age of the child or children being cared for, the name of the school or place that is unavailable, a statement. This can be via email representing that no other suitable person is available to care for their child. And if care is needed during daylight hours for a child older than 14, they will need to provide a statement that special circumstances exist requiring the employee to provide care. So the general consensus is that a 14-year-old generally should be able to care for the majority of their basic needs with a parent in the house. But they do allow for this in case there's certain circumstances that would prevent that from happening. One of the questions that I received often is the provision for the small business exemption for less than 50 employees. Certainly that would include a large number of our chamber membership. So I want to clarify that the exemption only applies to the childcare provisions of the EPSLA and the EFMLEA. So this is only for childcare. The sick leave for, due to quarantining due to the recommendations of a healthcare provider or all of the other reasons, I believe there's 5 other ones, are still mandated. There's no exception for that. So the exception can be granted if an authorized officer of the business has determined one of the following 3 conditions. First, that providing the paid sick leave would exceed available business revenue and essentially close the operations. The second is that the absence of the employees requesting the leave would cause substantial risk to operational capabilities and therefore could possibly cause operations to cease or cause significant damage to the operations. Or number 3, there's just not enough sufficient workers available to perform the labor provided by those employees or by that employee group. The Department of Labor has determined this exemption is not something you apply for. It is rather something that you need to document sufficiently to maintain in your own records. So the department has also clarified that it wouldn't bring enforcement actions against any employer for violations that occur through April 17th. So we are a little bit past that as of this recording. However, please note that, as we're explaining some of these provisions, if you made a mistake or didn't interpret something quite well, you do have the opportunity to go back and try to make corrections in good faith, and the Department of Labor will not hold employers liable as long as they're doing their level best to make corrections for how they administered this leave in the early days without the guidance. River Rose has an FFCRA leave request form on our COVID-19 resources page that you can find at the link below, and this is a very easy to follow document that you can send to employees, which will allow them to select the reasons for their leave request, the dates of that request, and also walk employees through the documentation needed to send to their employers. So you can find that at the kerberrose.com COVID-19 resources webpage. So we'll move on a little bit to the CARES Act signed on March 27th, 2020. This was a $2 trillion stimulus package used to combat COVID-19 and provide financial support across numerous areas of the economy. It provided direct financial assistance to taxpayers, provided aid to hard-hit businesses, both large and small. I'm sure many of you have heard of the PPP loans or the IDA loans. It provided additional aid to hospitals and also allowed for a significant expansion of unemployment benefits. So I'm going to take a few minutes to talk about how those work and when unemployment comes into play and when the FFCRA leaves would come into play. There seems to be, understandably, a lot of confusion as to who applies for what based on the specific circumstances of the employee. So unemployment insurance, there were 4 big areas that this unemployment insurance was expanded. First, it provided an additional $600 weekly payment in addition to the weekly benefit amount, essentially for anybody who is receiving even $1 of unemployment. It increased the maximum number of weeks an individual receives benefits. It expanded coverage to workers traditionally not eligible, including the self-employed, independent contractors, those with limited work history. More specifically, it allowed benefits for people who had jobs pending and the offers were rescinded due to COVID-19 slowdowns. And it also provided significant support for short-time compensation programs, also called work share. We'll talk about each of these in a little bit more detail. The Federal Pandemic Unemployment Compensation, or FPUC, we like our acronyms in HR, provides an additional $600 a week to the established weekly benefit amount. And this will take effect for any claims that occur from April 5th through July 31st, 2020. So this will be paid out for any week in which an individual receives unemployment benefits. I'd like to remind everyone this is considered taxable income, just as regular UI insurance would be considered. However, they did specify that this amount will be disregarded for Medicaid or CHIP eligibility. So if a claimant is eligible to receive even $1 in unemployment insurance, they receive the FPUC reimbursement of $600 per week in full. So one of the questions I've gotten, Nancy, I'm sure you've probably heard this a few times as well, is in many situations with, especially, some folks that have income on the lower end of the scale, they could end up coming out better on unemployment. And a lot of the question is, why would they do that? Because it really isn't incentivizing employees to come to work or to search for other jobs. Unfortunately, the reason is just really one of technology. The software that most unemployment systems were built upon around the country have not been updated for many years. In fact, the software that many are built upon was last taught in universities in the 1980s. So the time it would have taken to adjust these systems and upgrade them to a way that could scale the income would have been a lot of effort, much too late to help. So it wasn't intentional. It was really more of a necessity in order to get money out quickly. That's also why you see the delays in unemployment getting into the hands of the people who are applying. Actually, it was just this week that these $600 stipends have been starting to be made available, even though this legislation went through exactly a month ago. So as part of the unemployment expansion, we have the PUEC, which provides an additional 13 weeks of unemployment benefits for a total of 39 weeks. So the expansion is 13 weeks in addition to the traditional 26. And then we have the PUA, which is the Pandemic Unemployment Assistance. This provision expands coverage to workers that aren't traditionally eligible for UI. So that would be your independent contractors, self-employed, and those with rescinded job offers. I would like to note that the Wisconsin Department of Workforce Development did not have their systems updated until just this last week to accept those claims. So if you did make a claim and you qualify under the PUA, it's very possible that you may have gotten a denial letter or that it wasn't accepted. So make sure you follow up somehow with the DWD if you fall into that category and your claim didn't process correctly. I've heard quite a few employees who've been in that situation. So they also greatly expanded the work sharing programs. The work sharing programs it's one of those programs that's not very popular or not very well known with the DWD, but it provides a really great resource for any employers who are looking to reduce their employees' hours, as it provides a little bit higher benefit to the employees in terms of their unemployment insurance allowance that they're able to receive if they apply under the work share program rather than getting just partial benefits from unemployment insurance. The unemployment insurance that's paid out under work share is also backed 100% by federal coverage, so it should not ding your employer's unemployment bank. So how this works, and I don't pretend to understand the exact calculation that the DWD uses to calculate their partial benefits unemployment, although if you are they do have some very great calculators on their site for people to use. However, claimants for the FPUC, so the weekly benefit amount in the state of Wisconsin is $370. So what the work share does is reimburses the employee commensurately with the amount their hours have been reduced. So for example, if the individual's hours are reduced by 40%, they would receive 60% of their regular wages and 40% of that partial UI benefit. So 40% of the $370. Plus they would receive on top of that the $600 FPUC payment. So in some cases, you could pretty significantly reduce the payroll expenses for your company and ensure that your employees are not significantly financially harmed in the interim. So it's really a great option. I've spoken with the DAWD. You do need to apply for this program. However, I will say they are prioritizing all of these work-share applications. So it does not sound like there's a significant lag in getting these approved and processed. I believe last week the Wisconsin legislature updated their provisions of the work share. So they've updated their program to reduce the participants to only a minimum of 2 employees. Previously, it was 20 employees or 20% of the workforce, so it applied more so to the larger employers. So they've reduced that grouping where you only need to have 2 employees on this program at a time. The reduction of hours also can be a set percentage, anywhere between 10% of their hours and 60% of their normal hours. And this would qualify for full-time, part-time, salaried, and exempt employees that are able to participate. So the eligible employees must have been employed by the employer for at least 3 months on the effective date. And if you're interested in this program, I would encourage you to visit the Wisconsin Department of Workforce Development. They have an email address. They're very quick to respond. So if you have any questions or are interested in this as a solution to reduce some of your costs and get a little extra benefit for your employees, I'd encourage you to look at this. So one of the final areas that unemployment was expanded was that they did provide additional support for tribal governments and nonprofits. Anyone who does not have the pay per worker, or they do not have to utilize the pay per worker unemployment taxes and instead have the reimbursable arrangements. So the federal government will pay 50% of that reimbursement, and then workers are also eligible for the FPUC supplement of that $600. They did expand the availability of UI for those nonprofits and tribal entities. So again, if you have questions, you are welcome to reach out to me. I don't have my email on here, but you can certainly find it by navigating to the Kerberos website. And we have some great resources on all of our programs at the Kerberos COVID-19 resources page.
Awesome. That's great information, Melissa.
Great. Nancy, do you have any questions that you've heard come up with any of your small business?
I know like you mentioned, there was frustration with some of our independent contractors with how they had to wait. They applied for unemployment and were turned down and then had to reapply last week. So hopefully they were able to get through that second time. But I certainly hope people are taking advantage of these resources that are available to them. And I hope that our small employers are able to navigate everything. It's an awful lot for them right now. So, you gave them some good resources. Department of Workforce Development is a great resource place to go to for information. So.
One item that I just wanted to add on, I have had a lot of questions about how the interplay comes in. When are people eligible for unemployment versus the FFCRA? The easiest way to explain that is if there is work available and the employee is not able to perform those duties because of one of those 6 reasons under the FFCRA, then it is under the FFCRA. If there is not work to be performed, then it falls under unemployment. So if there's not work available, the employer does not need to provide payment under the FFCRA. Technically, that would go just as you normally would, where you'd have to make the decision of whether or not you have a reduction in force, a reduction in hours for your staff, or a temporary layoff or a furlough, in which case then they would be eligible for that unemployment piece.
All right, excellent. Thank you for that clarification. And thank you so much for sharing your expertise. You're so knowledgeable in this area and so generous of your time, so we appreciate that very much. And we also have other resources available on the Chamber COVID-19 Small Business Resource page. That's on our website, shawanoecountry.com. So again, thank you so much, Melissa. We
Thanks for
appreciate
having me,
it.
Nancy.
All right, bye-bye.
Bye.